Okay, let's finish this up. We're on defenses. So now we know the categories of laws, categories of crimes. We know what constitutes and what we need in order to charge someone with a crime. We need the mens rea, guilty mind. The actus reus, guilty act. And a combination of those two to, in fact, say the corpus delicti in addition to the mens rea and actus reus are met. All the pieces are there, all the elements of the specific crime you're being charged with are there. Now we're ready to go into court, and we have an individual who's allowed to defend himself, and they come up with defenses. So let's look at some common defenses. Competency is one of those common defenses. The defendant must be declared competent to stand trial, and they must be able to show adequate skill and qualification to understand. So a defense attorney may claim that their client was not competent at the time they committed the crime, meaning they didn't have an understanding. They weren't culpable. They weren't understanding what they were doing was wrong based on whatever they come up with. In addition, if that doesn't work, sometimes they'll say they're not competent to understand what they did as a direct injury after the crime. They are no longer competent to understand the charges being brought against them. And in our courts, you have to be competent to, at the time of the crime and at the time the charges are being brought up against you. You have to be able to understand what you're being charged with and what penalties and punishments you're being faced with. Okay, so that's a competency. There's also the mental, if one is mentally incapable of committing the crime, they have the diminished capacity, in which the defendant must have the mental ability to form, as I said, much similar to the competency, the ability that is required in the mens rea, the guilty mind, the understanding and the intent. A young child, 3 or 4 or 5 years old, in the store, wants a candy, takes the candy, has not reached the point that they recognize that that's wrong, that it's not theirs, they can't just have it. You might say they have the diminished capacity, or they are not competent to fully understand. The mentally, for lack of the right word, mental incapacitated, has some serious birth defect that allows them to have less than an average intelligence. That might come into the play with the diminished capacity, the inability to know right from wrong, or again, as we said, the mens rea. Mental illness, though, is a medical diagnosis. There are people out there who have been medically diagnosed to have a mental illness, and a defense can come into play that says it was a result of their mental illness that caused them to do whatever it is that they did that they're being charged with. Don't get mental illness confused with legal insanity. And we call it legal insanity because it is a legal term, not a medical diagnosis. Mental illness, medical diagnosis in which you can get possible treatment for. Legal insanity suggests that the defendant did not understand or applies if they were insane and unable to basically act in any kind of a normal, intelligent way. We may say that they were actually insane. And however, contrary to what most people think, there's very few occasions where the legal insanity term as a line of defense is used. My recent readings say that less than 1% of the people even go in saying they were legally insane, and 20% of the 1% might be found not guilty because of insanity. So it's not a plea that's often used. And when you come back to class, I'll give you a few more pieces of information on the legal insanity. So it's the defense only applies if the accused was insane at the time of the crime, like temporary insanity based on whatever the situation is. As long as you can convince the jury, because again it's a legal definition, is not a medical diagnosis. So your behavior is what's going to have to get them to see that you were insane, not necessarily a doctor's diagnosis. And again, any of these competencies are, they go to a hearing, and the hearing obviously listens to both sides, and the judge will determine one's competence or diminished capacity, proven or disproven by the preponderance of the evidence. Even with these defenses, one may still go through trial. A defense does not mean you won't go to trial. It may possibly alter the verdict that the jury comes up with, jury or judge. So when you're looking at the 4 verdict outcomes, when defenses have been presented such as these, the jury can still say you're guilty. It doesn't matter what your defense was. You might say incompetent, mental illness, insanity, etc., but they say straight out, you're guilty. The jury may say guilty but mentally ill, at which point perhaps you will be sent for treatment as opposed to a traditional incarceration. If that is an option that's available. As a result of your defense, the jury may find you straight out not guilty. Or the jury might find you guilty by reason of insanity, at which point we recognize, or the law helps recognize, that it excuses the person from their actions who is deemed to be legally insane. So again, it would be an excused activity of whatever you've done. Okay, we're nearing the end here now. It's been quite a bit of information, but you missed me on Thursday, on Wednesday and Thursday. So let's take a look at self-defense. Self-defense is an acceptable excuse that when the prosecutor looks at your actions and recognizes that it's a self-defense, you may possibly not even be charged. And there are parameters that must exist. You must reasonably and honestly believe that you're in immediate harm. When we're talking about a self-defense and deadly force, can't imagine we're going to be talking about anything else. You're not going to have self-defense and break-in. Self-defense is used in physical actions by what was once considered the victim. So if you ever use deadly force and it is a excuse or correction, a self-defense that is presented, you're not allowed to use deadly force for any minor injury, and you must fear 3 things before deadly force is allowed to or recognized to be used. You must be in belief that you are facing death yourself. You must fear that if it's not going to be death, it may be or will be serious physical injury will occur to you. Or in Michigan, we do allow for one to use deadly force as a means of self-defense when one will be forcibly sexually penetrated, or in essence, a forcible rape. So any serious harm, death, or forcible rape, we are allowed as a potential victim to use deadly force to escape those, as long, again, as we fear and we're not going to just have minor injury. So we have to reasonably and honestly believe that this immediate harm will come to us. We can claim defense of another. We're allowed to protect another from danger using force of different varying degrees if, again, we honestly and reasonably believe that it is necessary at the time, and that, again, they too will have immediate threat of death, serious injury, or forced penetration if we do not use force. Okay, there is another defense, and it's called the perfect defense, an alibi. Many of you may have heard the word alibi before, and many of you may think it's an excuse. But an alibi is perfect because it's not an excuse, but rather it's the lack of presence. The lack of presence meaning you are not at the place where the crime occurred. So therefore,